Chris Valentino from Jackson Lewis. Welcome to our February edition of Last Fridays. What we want to do today is follow up with what we did in January. As you may recall, in January we talked about new gender equity laws in New York, and I specifically focused on the exposure that is created under these new laws for employers with regard to pay disparity. What we have seen since then is, what I'll call an explosion on a federal and state level with regard to initiatives to weed out pay disparity in the workplace, likely emerging because of the fact that on a federal level, President Obama has taken this issue very seriously over 8 years, and nothing really has happened. So we're going to see a tremendous amount of movement in this area over the next 10 months, but nothing bigger than the proposed revisions to the EEO-1 report and the obligations that, when finalized, if finalized, it will create for employers. To talk about that, I've asked Eric Felsberg, who many of you know is expert in the area of AAP, OFCCP, and he is leading the charge for Jackson Lewis nationwide on these pay equity issues and also the new EEO-1 report. So I'm going to turn the webinar over to Eric.
All right, well, thanks, Chris, and good afternoon, everybody. I'm happy to be here, happy to talk to you about some of these pay equity issues that we've seen come around over the last several weeks. What we're going to talk about today is the EEOC's proposal that they came out with a couple of weeks back regarding securing employer data of those employers who are subject to EEO-1 report filings. And we're going to go through all the components of the proposal, offer you some best practices, and do all of that in about 20 minutes time or so. Before we get into the substance of the presentation, I just want to offer you a bit of a disclaimer. Chris and I, as you know, are attorneys, and we feel much more comfortable if we offer a disclaimer first. We're going to be talking about some real kind of cutting-edge enforcement developments, as well as how you can respond to them in a meaningful way. One of the things that I would urge you is just don't simply take what we talk about today, kind of just lay it on top of your compliance plan and think that everything's going to be okay. Each of these situations that we're going to talk about today, some of the initiatives that Chris referred to, really become very fact-specific. So we would urge you that before you take any action on any one of the things that we talk about, that you consult with your counsel, whether that be Jackson Lewis or otherwise. But for today's topic, as I mentioned, the EEOC proposal to collect pay data from employers, this is a very significant development, as Chris mentioned. Back on February 1, the EEOC had proposed, had issued a proposal where employers who are subject to the EEO-1 report filing, and I'll describe who those folks are in a moment, would have to, if this proposal goes in, offer up as part of their filing W-2 earnings as well as work hours for all employees that are covered in their EEO-1 report filing. Now, for those of you that have ever had the pleasure of filing an EEO-1 report, you know that what it requires you to do is to report presently. What it requires you to do is to report on the race, gender, and ethnicity of all of your employees, and then break those totals down into EEO occupational categories that the EEOC has made available. Categories like professionals, technicians, sales workers, etc. What the EEOC is now proposing is that in addition to providing all of that information, you would also have to fill in a number of columns that kind of attached to the EEO-1 categories, where you would provide total compensation for your employees. Now, this is not going to be employee level specific data. It's going to be reported in pay bands, as we'll see in a moment, broken down into these EEO categories. But this is going to be a significant burden for employers if this proposal goes through as it's currently proposed. And it would start with the 2017 EEO-1 report submission. So that's not the EEO-1 report for this year. It's going to be about a year and a half from now, from starting in July 2017 until September 30 of 2017. That would kind of be your filing period that what we're talking about today would be impacted. Now, what is the EEOC and why are they doing this? As Chris mentioned, the Obama administration, as you probably have been aware, has been very keen on eradicating what they feel is pay inequities, especially in the area of gender, right? The pay gap between men and women has been talked about a lot over the course of the Obama administration. It's been covered in the press. And really, right from the White House, the president has been really putting a lot of pressure on some of the enforcement agencies like the EEOC and the OCCP to come up with tools to help this administration eradicate any sort of pay gap that may exist. And so what we're talking about today, the EEO-1 report amendments, is the EEOC's response to that directive. And again, they're going to be asking for pay data, as we'll see in a few minutes. Now, as you know, the EEO-1 report doesn't just apply to federal contractors, right? So if you're, generally speaking, an employer who employs at least 100 people, it doesn't have to be all in one place. It could be kind of spread across the nation. You have an obligation to file an EEO-1 report, regardless of whether you hold any federal contracts. Federal contractors, those are those employers that are doing business with the federal government in some respect, they also have to file an EEO-1 report so long as they have at least 50 people and the value of the contracts are $50,000 or greater. So we're not just talking about federal contractors here. This proposal covers employers if you have at least 100 people, generally speaking. Now, the comments to the proposal that we're going to talk about today, the EEOC is accepting comments, right? And you can submit those by April 1. The EEOC is also going to have a public hearing to consider some employer concerns around the provision of this data to the EEOC. As luck would have it, today is February 26th, I believe. If you wanted to speak at the public hearing, unfortunately, you've missed your opportunity because you had to submit a letter of intent to the EEOC by February 22nd. So unfortunately, you're not going to be able to speak, but you may be able to submit some comments to the EEOC and let them know what you think about this proposal. Now, what is the requirement going to require you to do? The EEO-1 reports are going to require, as I mentioned, that you provide to the EEOC W-2 earnings, right? So what does that mean, right? If you think about when you issue a W-2 to your employees, usually by the end of January, right, you're not just reporting to those employees any compensation that they received as a part of their base salary, right? You're reporting on any monies that employee received from you during the previous calendar year. And the EEOC is asking for that same information from you. As we're going to see in a moment, it's based on a different time period, however, and that's one of the difficulties that you're going to encounter if this proposal goes into effect. Now, if you've ever filled out an EEO-1 report before, you know that there are 10 EEO-1 categories, and we touched on a few of them before: professionals, technicians, sales workers, etc. There are 10 of them, and right now what you're required to do is kind of fit all of your employees in the aggregate into each of the race, gender, and ethnicity categories broken down by these EEO categories. What the EEOC is now proposing is that in addition to doing that, you're also going to have to provide information broken down into 12 predetermined pay ranges that are established by the EEOC. That will basically total up to give you 1,680 options as to the way you fill in this grid when you file your EEO-1 report each year. Now, you know that you file the EEO-1 report in the third quarter of every year, right? So for 2016, later on this year, when you file your 2016 EEO-1 report, you're required to use a payroll period between July 1 and September 30th of the reporting year. So if you're filing your report in September of 2016, you're going to be providing information on from a payroll period during those preceding, say, 2 months going back to July 1. Now, if you ever have been involved in issuing a W-2 to your employees in compliance with IRS requirements, you know that those W-2 earnings are based on the previous calendar year, right? And you have to provide total earnings to these employees by the end of January so they can have them to file their taxes. If this proposal goes through, what you are going to be faced with is not only running a W-2 payroll run for the January timeframe, but you're going to have to do the same exact thing come July through September later in that year, right? Because the EEOC is not proposing to change right now the time period that you would have to report on. So just be prepared by way of burden. You're going to have to do basically a W-2 run at 2 points during the year. You're also going to have to report on hours worked, right? So this is going to be the total number of hours worked by employees separately in each pay band, again, broken down by race, race, ethnicity, and gender. And that, again, comprises some of the burden that I keep referring to that you're going to have to endure when you're filling out your EEO-1 reports. Now, why is the EEOC doing this, and what are they and the OFCCP going to do with this? Again, the OFCCP is the agency within the U.S. Department of Labor that enforces the affirmative action regulations. They are working with the EEOC on this particular proposal, right? So when you submit this data in 2017, not only will that data be going to EEOC, if you're a federal contractor, it's also going to be provided to OFCCP. Now, they claim that they're going to be using this pay data to assess complaints of discrimination. So both in the EEOC and the OFCCP worlds, an individual employee or applicant, for that matter, can come forward and file a complaint of discrimination with one of those two agencies, and those agencies have a duty to investigate. And if it's pay-driven, if there's a component of that complaint that involves pay, you can be sure that the EEO-1 report data that you've submitted to the agency as part of your EEO-1 report will be considered as part of that investigation. It's also going to allow these agencies to focus their investigations and identify any existing pay disparities that may warrant further investigation. Both of these agencies have the ability to initiate an investigation if they feel that the laws that they're responsible for enforcing may be violated. Now, what you're essentially doing is you're going to be giving additional data to the EEOC, so they're going to have that in hand as a way to kind of target employers for review investigations, and on the OFCCP side as part of compliance review investigations. Now, the EEOC is also, as part of this proposal, planning to publish aggregated data that they receive from employers across the nation by industry and geography. Now, they claim that they're going to do this to help employers, you'll see on the slide, help employers in conducting their own analysis of their pay practices to facilitate voluntary compliance. The good news, I guess, here is that even though they're going to publish the data, they're not going to publish it in a way that will be easy for somebody to identify which company provided that data. However, there are some confidentiality concerns that people have right now given this proposal. What if you're the only employer in a particular industry, in a particular geographic area, right? So you have a plant or maybe a small facility in a sparsely populated part of the country, and you're the only kind of business in town that does just what you do. Presumably somebody could try to make a FOIA request under the Freedom of Information Act and try to secure that information from the EEOC or otherwise to maybe find some information about how you pay your employees at that particular facility. Other employers that are competing with you, if you're one of two, say, employers in a particular area that do what it is that you do, perhaps your competitor is going to try to secure that information to gain some sort of competitive advantage over you. And it may be used by people that you're trying to recruit, right? If there's a tight job market and you're trying to secure folks to come work for you, and they see, hey, once they get an offer from you, this is what you're willing to pay, but based on the aggregated data that the EEOC made available, perhaps you're below market, you're below what everyone else is paying, and that may prompt that individual to go work elsewhere. And of course, if you have very few employees in a particular EEO-1 category, or perhaps you have very few employees of a particular race or gender in any of those categories, presumably somebody could back into that information if they were so inclined. Now, one of the things that you need to be aware of is that the EEOC right now, and this may kind of weigh into whether you would like to submit a comment to EEOC to kind of inform them and educate them, but they vastly underestimate the burden that you, the employer, is going to have to go through in order to comply. Again, you're going to have to submit race, gender, ethnicity data by EEO category, and that's usually something that may be stored in your HRIS system. Usually, if you're like most employers, W-2 earnings and hours worked are stored in a payroll system. So in order for you to comply with this requirement, you're going to have to first secure all the information on the demographics, right, the race and gender from the HRIS system, and then kind of match that with data from your payroll system so that you have one data set that's kind of, from an internal perspective, possesses some level of integrity so that you can report in good faith to the EEOC. The good news is from the EEOC's burden is they say, hey, don't worry about it. We don't care how big you are, how small you are. we've done a study, rest assured, and we think it's only going to take you 6 hours to do this. So whether you have one facility or you have 100 facilities across the nation, it's only going to take you 6 hours either way. And by the way, only $160 it's going to cost you to actually comply with this. Now, you know, I'm being a bit facetious, and I think most employers think the same way, because doing anything in 6 hours, whether it's to write a letter or do reports for 100 facilities, you're not going to get that done in 6 hours, and it's going to be submission ready in that limited amount of time. But nonetheless, that's what the EEOC thinks, and I think a lot of employers are considering submitting a comment along those lines with regard to the burden that we keep coming back to. Now, that's the proposal, right? So in a nutshell, you're going to have to submit pay data. It's not just base, it's W-2 wages that is going to be submitted to EEOC. If you're a federal contractor, that gets shared with OFCCP, and now the government has an additional layer of data that they're able to use when they investigate or choosing whether to investigate you. As Chris mentioned, this really kind of came out of President Obama, you know, this administration's concern over, again, these pay inequity issues. But if you've been following the dialogue around that issue, it's primarily kind of dealt with gender. It's really kind of looking at how do we correct this pay gap between men and women. Just keep in mind, if that's really the EEOC's response, not only are they asking you to submit data based on gender, but you're also submitting by race and ethnicity. So it's kind of above and beyond that mandate that they have from this administration. Now, in terms of homework that you should be thinking about going forward, first and foremost, determine whether your organization is required to report on the EEO-1 report. I covered it at the beginning. Generally speaking, if you have 100 employees and you're, you know, regardless of whether you have a federal contract, you have an obligation to submit an EEO-1 report, and by extension now, if this goes through, would have an obligation to submit pay data as part of that submission. Secondly, if you're a federal contractor, it's the 50 rule, 50 employees, $50,000 in federal contracts or subcontracts. That would also trigger the obligation. So that's kind of a threshold issue that you have to think about. If you are covered and you're concerned about some of these burdens, consider submitting comments. I can tell you from experience that having been in this area and reading comments that OFCCP and EEOC receive, these things are taken into account. If you're interested in submitting a comment, you can speak with Chris or me, and we can either work with you to submit a comment, or there's industry groups out there that are also considering doing the same. Whether you submit a comment or not, but you think that you're covered, really strongly consider conducting a proactive EEO pay self-analysis. You have to assess the risk here. And that's not a decision that should be made just by you. This needs to be an organizational decision. But understand, the government's going to have your pay data. You need to understand what that pay data says before you give it to them. You don't want to be explaining it during the course of an investigation. But before you embark on an analysis, you need to make sure there's organizational buy-in to deal with not only the analysis, but the output from that analysis, namely whether there are disparities and there needs to be some level of remedy. If you're going to undertake the analysis, which we strongly recommend, certainly, and I can't recommend this enough, and perhaps this is the most important bullet on this list here, you need to make sure that analysis is conducted under attorney-client privilege. While we would love for you to work with Jackson Lewis, and we're certainly equipped to help you with that, if it's not Jackson Lewis, just make sure that you are working with an attorney on this, because again, you want to protect against the discovery of the analysis either during an EEOC, an OFCCP, or perhaps even a private piece of litigation that you may be faced with. So that is just absolutely critical. And then last but not least is give a heads up to your IT function as well as your HRIS and payroll system vendors. See if they have a fix for this in the systems that you use, so that we can automatically kind of marry the two data points together that I talked about before, and also alert them about you know, upcoming needs that you're going to have, both from a budgetary standpoint as well as from just a pure resources standpoint within the coming year. So that's a lot to take in within 20 minutes, but we hope that was helpful. As I mentioned, feel free to reach out to either Chris or myself, and we'd be happy to walk you through some of the things that we talked about on today's program. Thanks, everyone.
Thanks so much for joining us. We'll see you next month.